Good afternoon and welcome to the Fox Williams Fashion Law webinar. My name's Steve Sipkin and it is my pleasure to welcome you today to our webinar, which is going to be looking at the issue of brand stock, stores or other assets. What do you need to know when buying from a distressed seller or its administrator? I'm pleased this afternoon to be joined by my partner, Paul Taylor, and our colleague, Georgie Glover. Both Paul and Georgie are lawyers in our corporate department. They're also members of our fashion law group, and they're going to be taking us through the webinar during the course of this afternoon. During this afternoon, they're going to be discussing the advantages and disadvantages of buying assets from a distressed seller before they enter into a formal insolvency process. What are the differences between buying assets from a distressed seller or from a solvent seller? The importance of due diligence, third-party consents, including the release of bank security. What are the risks involved in Felix trading? And then they will conclude with practical tips and we'll be able to move to a Q&A. So, Paul, Georgie, over to you in the context yesterday, of course, of Next acquiring the intellectual property of Cath Kidston. So, very topical. I look forward to hearing from you.
Thank you, Steve. As Steve said, we are hoping to discuss all of those issues in 20 minutes. I'm not going to thank Steve because he's nicked my first line, which was supposed to be about the Next and Cath Kidston, but that was a perfect example in a fashion setting of what we're actually going to talk about. So we're going to come on to sort of 10 practical recommendations if you are looking to buy assets from a distressed seller. But before we do that, I think we're going to depress the hell out of you because we're going to give you a load of very, very gloomy fashion insolvency statistics. So I'll kick off with last year, every week, 50 shop sites closed in the UK during 2020. That's according to Drapers.
In 2022, business insolvencies jumped by 30% to 13-year high as government support programs that have been offered to companies during the pandemic came to an end.
Continuing the gloomy outlook, the total number of company insolvencies registered in England and Wales reached 22,000 according to official data. And that is the highest since the sort of bank-led recession in 2009. And it's 57% higher than 2021, when obviously we're in the peak of the pandemic. The latest issues that we have available are for February 2023, and in the month of February 2023 alone, there was 17% higher insolvency, 1,783 in February, and that was basically 33% higher than 3 years previously when we were actually entering the pandemic. So quite scary numbers.
So, as we all know, the British High Street has taken a bit of a battering over the last few years, and we've seen a lot of retailers close their shops, both their brick-and-mortar stores on the High Street, but also their e-commerce offerings. Topshop, TM Lewin, M&Co, Jewels, Made.com, Misguided, Laura Ashley, Bon Marché, and now Cath Kidston, to name a few. While some of these will go on to have a second act elsewhere, like Tesco selling paper-chase stationery or ASOS selling Topshop clothes, for others it's curtains.
Literally curtains. So I'm now coming on to the 10 recommendations. So here we are assuming that you good people are the buyers. So you've basically, through your network, you've discovered the opportunity to buy some sort of distressed assets. And when I say distressed assets, I probably mean assets from a distressed seller. The first one is timing, and what I mean by timing is when are you going to do this purchase? So you have basically a choice of two main structures. The first structure is to buy from an insolvency practitioner. And if you buy from an insolvency practitioner, the company has gone into insolvency, and basically the insolvency practitioner blesses the price that's being paid. And what I mean by that is it's going to be very, very difficult post that transaction to challenge that price that's paid. So if you're buying from an insolvency practitioner, there are downsides, but probably the main upside is you are not going to have the transaction set aside subsequently. If you are buying pre-insolvency, so you know that the seller is in financial difficulty, but effectively you're dealing with directors. You just need to be very careful about the price that you're going to pay for those goods. Now, the reason you should be doing this is we are getting a knockdown price. But if you are buying in those circumstances, there is a risk that if the seller then subsequently goes into insolvency, and in the UK, that challenge period is effectively 2 years, the liquidator, the subsequently appointed liquidator, could look at that transaction and basically get it set aside. So the way that we protect you, basically lawyers, we would make sure that transaction is papered properly. And what I mean by that is making sure you have things like valuations. We make sure that we have proper board minutes for the sellers. We might include declarations of solvency of those sellers. So it can be done, but extra care is needed in those circumstances. Moving on to Georgie for our second recommendation.
Our second tip is to check the validity and the extent of the appointment of an insolvency practitioner. If you're buying assets from an insolvency practitioner, you need to satisfy yourself that the necessary procedure has been followed, because this will mean that their appointment is valid. As the buyer, you can and you should ask to see copies of the sealed appointment order. Now, why is this so important? Well, it's vital that the insolvency practitioner is actually authorised to sell what they're purporting to sell. Otherwise, you may find yourself getting an angry knock on the door from some disgruntled creditors down the line. Okay, so once your administrator is validly appointed, then what? Where there's a group of companies in administration, you also need to check which entity is selling the assets. Is it clear who owns the assets being sold? It's possible that an insolvency practitioner might be appointed in respect of one, but not the whole group of companies. And so you need to be sure that you're dealing with the right people. Where there is a group of companies, the most valuable assets may not necessarily be held by TUPE. They might spread amongst the group. So you mustn't assume that entering a transaction with TUPE means you're going to get all of those big ticket items. And similarly, will there just be one overarching sale agreement for all these companies, or will each subsidiary be subject to its own sale? You just need to really make sure you're clear on what you're buying and from whom.
Moving on to the third thing, and at the risk of repeating myself, because I've already mentioned this, it's price. You are only doing this deal because basically you have sniffed out a potential bargain. If you were paying proper prices for them, you would be buying it from a solvent seller where you have loads and loads of sort of valid protections. But if we're talking about a distressed sale, it should be a distressed price. Now, when I say distressed price, if you're looking to say buy freehold property, it won't be a distressed price because that is a perfectly sort of liquid. You can sell that asset, there will be plenty of buyers from it. But if you're buying, say, stock, for example, there should be a healthy discount. Drilling down on the three likely scenarios, if it's solvent, I've already said, if it's too cheap, it can be challenged subsequently, so it needs to be papered properly. If it's an insolvent sale, so you're dealing with, in the UK, it would be a liquidator or administrator, just for your sort of information, the liquidator or the administrator doesn't need to get the best possible price, but they have to show that sort of a reasonable price has been paid. And that's normally done by them bringing in a valuer. The other thing to note is if it's a connected party, and quite often the most likely connected party is going to be a pre-pack. So a pre-pack is normally applies when you have the management of the old co goes into insolvency and management set up a new co to buy the goods. And in that situation, I think it's fair to say it has been terribly abused in the UK over the years. And the government keeps trying to crack down to make sure that that abuse won't continue. Now, if you have that connected party nature, so if you have an old management team member who's also party to the new co, that price and that whole transaction needs to be signed off by an approved person. And apologies for getting technical, but the usual approved person is somebody called the pre-pack pool, which is an organisation. They come in, they look at the sale, and they will basically say, yes, we think that is a sensible deal to be done. If you're not bringing in the pre-pack pool, you can bring in an insolvency practitioner to sign off on the terms. Moving on to the fourth tip.
Fourth tip is consider the bank or the store landlord or the trademark owner's position. Think about the creditors of the business that you're acquiring. Could any of those creditors have taken security over the assets of that business? Or could the assets be subject to retention of title clauses? It's really important to carry out a search against the seller to establish whether there is any outstanding registered security over the asset. An insolvency practitioner won't sell assets with those charges removed. So if you're buying assets that are subject to a charge, you need to obtain consent from the charge holder first. And you need to go to them directly to do that. The last thing that you want is to purchase a load of assets and then realise somebody else has got a better claim over them. In addition, the business might be using or selling branded goods. So Cathkidston is a great example. They've gone into administration and Next is purchasing brand and assets from them. And let's just say, for an example, that those assets include Disney pajamas. It's possible that when Disney's granted a license to Cathkidston to use and sell those Disney pajamas, that they've also included restrictions on Cathkidston's ability to assign the license to a third party. So here, where you've got this sale, it may mean that Cathkidston can't give Next the right to use those or sell the Disney pajamas without getting Disney's consent first. And that's not always easy to do, particularly in a short time frame when time is of the essence. So you need to consider whether branded goods and assets are material to the value of the business that you're acquiring.
Our fifth recommendation, and I'm going to show my age. So going back about 50 years, I was in the Scouts and the Cub Scouts, and their motto, their famous motto, was "Be prepared." And that is certainly something that we would advise you to follow if you're looking to purchase assets. And what I mean by that is, if we're doing a solvent sale, if you sign up heads of terms, you would be typically talking about a timeline of about 2 to 3 months from when you actually sign to when you sell. And that might be a very depressing fact, but trust me, I've been doing this for about 30, 35 years. And in that time, I've actually done M&A transactions that have celebrated a birthday. If we are dealing with an insolvency situation, you could be talking about 2 or 3 days, or at the most 2 to 3 weeks. So the purchaser that is moving quicker is at a huge commercial advantage. It's like if you're selling your house, you're going to ask for the offers and you're going to look at the price being paid, but I might give more weight to a purchaser that has got cash in the bank rather than somebody that has to sort of mess around with a mortgage. So how are you going to hit the town, how are you going to hit the ground running? It means that you should consider things like the following. Yes, consider incorporating a new entity, because if you're doing something sort of scary in terms of buying in assets from a distressed seller, you might be a little bit concerned about what you're acquiring, particularly if you're bringing liabilities into it. So ring fence that purchase by getting a new subsidiary and basically having all the assets and liabilities held in that ring fence subsidiary. I'd also recommend that you speak about, where is the funds coming from? Is it coming from debt finance, in which case you need to have very, very quick conversations with your bank. You need to have your internal deal team ready. So, you've got a finance director, have you got your sort of sales team, your due diligence team ready to go? You need to have sensible sort of professional advisors, lawyers like us, hopefully, or accountants ready to hit the ground running. And what you might be looking to do is actually negotiate with, say, the insolvency practitioner on what's known as exclusivity. And exclusivity is normally the buyer saying, look, I will pay something like, £5,000–10,000 to cover your fees, but for that payment, in consideration of that payment, we are going to have a free run at these assets. We don't want to be competing with another purchaser. So in an insolvency situation, you might get a week. In a solvent situation, you might get a couple of months, but you are saying in that week, you are only going to talk to us. And what often happens is that expression pre-pack. What pre-pack actually means is a pre-packaged sale, that all the negotiations have been done pre-appointment. So it's a slightly strange situation where you're negotiating with the administrator of the liquidator and you haven't even been appointed. So technically, you really haven't got any local standby at that stage, but you have the agreement ready to sell. You go to court, they get appointed, and then basically the first act of the liquidator or the administrator is to sign the sale agreement. And the reason for doing that basically means that the administrator or the liquidator isn't taking on trading risk. So they're literally just blessing the actual sale without actually having to run the business. I'm going to hand on to Georgie, who's going to talk about due diligence.
Yeah, so our sixth key tip is do your due diligence. Buying a business that's in administration can be a very risky business. In most cases, the purchase agreement with a distressed seller will be very short form and it won't contain the usual warranties and representations about the state of that business and how it's been run to date that we would usually see and would offer a buyer some protection. In practice, the insolvency practitioner is going to need to distribute the sale proceeds long before any warranty periods expire anyway. And what's more is they're actually going to be acting as the agent of the distressed business. So they won't be held personally liable for any issues that have been identified once the sale is completed, like breach of warranty claim. But as a trade-off for this degree of risk, as Paul said, you're likely to be purchasing the business and these assets for a very low price. And so it's vital that you carry out really thorough due diligence on the assets that you are acquiring, so that you can be absolutely certain of what you're buying, what condition it's in, and what skeletons are in the closet. As Paul was going on to tell you, it's very much a case of buyer beware, and it won't be the bargain that you hoped for if you complete the sale and you come to realise that you've purchased assets with a whole range of problems that you didn't spot.
And number 7, one-sided agreements. I don't want to sort of reduce everything to numbers of pages, but in its simplest sense, if I'm doing a solvent sale and I'm acting for the buyer, I would be producing the documents, and I would probably produce a document that's close to 100 pages, which is stuffed full of warranties, indemnities, tax covenants, etc., all extremely buyer-friendly. If you go into an insolvent situation, that is flipped. So you are looking at probably 20 pages, and the vast majority of those 20 pages are protections in favour of the seller, the insolvency practitioner, principally excluding personal liability. So there's a couple of takeaways from that. One, as Georgie was always saying, due diligence is key. If you get a dog with fleas, you are not going to be able to sue under that document because you're not going to have any protections. It's all down to how thorough your due diligence was. The second thing is, if you're a buyer competing with other buyers, so you haven't got exclusivity, if I mark up the sale agreement and send it back with 50 pages inserted saying this is outrageous, I'm the buyer, I want no protection, your bid will effectively be laughed away because the insolvency practitioner is saying that's totally off market in the UK. In the UK, it's a short form agreement and the protections there rather unusually are in favour of the seller, not the buyer. Moving on to the dreaded TUPE, the 8th point.
Yeah, our 8th point is to consider the employee position. So we touched on due diligence, and employment due diligence in particular is really important. Just appointing an insolvency practitioner will not automatically terminate the employment contract of the distressed business's staff. And in any case, you may find that you need to keep on a certain number of staff once the sale is completed to keep the business ticking over sometimes. Sometimes the insolvency practitioner will dismiss some of the workforce to try and make it more viable to buyers or to make it look a bit more commercially viable. But this has to be handled very carefully because there's a possibility that this may constitute unfair dismissal if it isn't properly, the correct procedure isn't followed. And that's where TUPE comes in. So the transfer of undertakings, protection of employment regulations, or TUPE, may apply in relation to a sale of assets of the insolvent company if that sale amounts to a transfer of a qualifying business unit. A sale of a business of administration will usually constitute a relevant transfer for the purposes of TUPE. And what that means is that the distressed seller staff will have the benefit of certain statutory protections. If a company is in liquidation and it's not trading at all, TUPE may not apply. But where it does apply, it's important because it provides for a lot of things. And the kind of key ones are that the staff's employment contracts will transfer automatically to the buyer with no variation as to their terms. The seller's liabilities relating to those staff that are moving across, like pension obligations, will also transfer automatically to the buyer. As I said before, it contains some protection for employees against the dismissal that is connected principally to the transfer and would constitute unfair dismissal. And it also sets out certain obligations on the buyer to inform the workforce and consult with trade unions and employee representatives about the transfer that's going to take.
For the penultimate one, so number 9, I'm going to talk about Phoenix trading. And this really came about, the concern here, in the, sort of the 1980s. There was a whole host of scandals where basically the same management team was set up. There was one in particular, I remember, that was the Land of Leather that became the World of Leather, that became the Land of Leather in 1983. And it was basically a series of businesses being set up, taking all the customer deposits, going into liquidation, and then doing another business with a very, very similar name, completely confusing the consumers who weren't aware that basically there was a repetition of the same management being involved in all these failed companies. So the law is sort of trying to get to grips with this with something called Phoenix trading, which is under section 216 of the Insolvency Act. And, you know, probably let's give the Cap Hidson example. So if the Cap Hidson business went into liquidation and a NewCo was set up, I know that didn't apply because Next bought it, but say if Next had set up a subsidiary called Cap Hidson 2023 or Cap Hidson Next Limited, so a very similar name. If they have similar directors, overlapping directors, so if directors of the failed company are now directors of the new company, those directors can be personally liable for the debts of the new company if that new company fails in the next 5 years. So that's quite a long period, it's quite a big threat. If you are one of those directors involved, and you know it's perfectly commercial, providing that you're not going into a sort of deliberate course of conduct to confuse consumers, but if you just want to, you've acquired the goodwill and you're concerned about that, there are 2 effectively processes to sort of sanitize that reuse of the name. You can either go to court and get approval, or the most likely one is a creditor notification process. So every creditor of the old co that is owed money needs to send a form basically saying, I was an old director of this company, and do not be confused. Going forward, I will also be a director of this new company with the same or a similar name. Moving on to the last one.
Our 10th tip is make sure you know which assets you're buying and which assets you're leaving behind. There is a major advantage to buying from a distressed seller, and that's flexibility. When the target business is in administration, as the buyer, you can effectively cherry pick the assets that you want, like the IP and the brand, without taking the burden of those that you don't want. And with this in mind, it's really important that the purchase contract is perfectly clear on what you are taking and what you're not taking. Between you should negotiate a specific list of excluded assets and liabilities, and this has to be included within the purchase contract. So there's no room for doubt in anyone's minds as to what's being sold. Excluded assets are just as important as the assets which are included, and unlike Forrest Gump, you should know exactly what you're going to get.
Just to very quickly recap, so in summary, and I'll try and keep this brief because I'm conscious time is against us, there are opportunities out there at the moment. You know, judging those statistics at the moment, there's going to be an awful lot of opportunities there. If you are looking at buying from a distressed seller, I think probably one of the most important questions is, am I going to buy it out of the administration, liquidate, or wait till an insolvency practitioner is appointed, or I'm going to take a risk and buy it beforehand? And if you are doing that and buy it beforehand, make sure that's properly papered. Number 2 is just due diligence. Make sure you are dealing with a properly appointed insolvency official. Number 3 is don't go into this unless you are getting a very genuinely bargain, good price, because otherwise you're taking a lot of risk and doing a lot of sort of due diligence and extra work. So that should be reflected in a knockdown price. 4, third-party consent. Look at the bank's position, look at any trademark's position, look at the sort of the landlord, whose consent do I need to do this? Go on Companies House, look if any security is registered, and if it is, you need a release because the liquidator doesn't overreach that security. You need a piece of paper from the bank saying that the assets are sold. also retention of title. If you're buying stock, it may be that the producer and supplier of that stock has got a prior claim, and you need to actually draw down on that. Number 5 was my scout motto, be prepared. So make sure you've done all your homework and you're in a good position to move forward. Georgie talked about the importance of due diligence. So you are not going to get pages and pages of warranty. So due diligence is absolutely key on this. 7 was one-sided agreements. Unlike a solvent sale, you're going to have a very short form agreement that is all in favour of the seller rather than the usual position of all in favour of the buyer. 8, TUPE. I did a transaction this week, actually, we're advising on it, and it was a US client, and they were absolutely mortified. They had no idea about the existence of TUPE, and they'd nearly entered into a contract and taken on a whole, it was a restaurant, taken on the whole restaurant staff. And you know, that's fine if that's a negotiated position, but if you're going into that blind and you have no idea about that legislation, that is a really, really serious trap to be unwary. 9 is Phoenix trading. That only applies if you're planning to sort of recycle or reuse the same or a similar name. And probably the most important tip at the end is the what are you buying? And on that, I would say it's not really what you're buying, it's what you're leaving behind, because you don't want to be taking on a whole list of liabilities, because at the end of the day, the company's gone under, and it's gone under for a reason, and it's probably gone under because it's got some sort of horrible liabilities that can't be settled, and you don't want to inadvertently find in the sale agreement that you've taken over responsibility for that. So that is a massively key point. Apologies for slightly going over the time, but we're going to open it up for questions and hopefully answers, if anybody submitted the same. Steve, I don't know if you've got any pre-prepared questions you want to lob in our direction.
I will in the absence of anything else. So, Paul, let's talk about overseas assets. Is it the case that the general principles, the top tips that Georgia and you have referenced, also apply to overseas assets, or should the prospective purchaser, particularly of assets and business from a distressed seller, be wary of anything?
Very good question, Mr. Sitkin. In terms of the nuances there, I think the first answer is, where are those overseas assets held? Because if they're held in an overseas subsidiary, so if they're German assets sitting in a GmbH, the next question is, are you buying the share capital of the GmbH? So that's an asset of the UK company that can probably be sold by an insolvency practitioner. But as the buyer, do you really want to take ownership of a GmbH in a foreign company which you have no knowledge of? If the German asset, for example, is sitting in the UK company, I'd say the next question is how important that asset. So if that asset is the reason that you're doing a deal, I would want German lawyers, German accountants, whatever it is. I would have my deal team to include German input just to tell me how the asset can be transferred. And if there was any sort of quirks, local law quirks that I need to be taken on board to, again, make sure I'm getting the asset that I want. And for example, I'm not suddenly inheriting a big German workforce turning up on my doorstep saying that they have entitlements under some, you know, esoteric German labor law that they can come and work for me.
Okay, thanks for that, Paul. And a further question. I'm sure I've read from time to time that a bid by a prospective purchaser has not been accepted by the administrators. Are there particular obligations, rules on the administrators as to what they accept by way of bid and where they can reject bids?
If you went back literally 5-6 years, again, the insolvency space was very much the Wild West. I think it is becoming much more sort of mainstream in terms of business practices. And partly that has come from sort of self-regulation, and partly that has come from government regulation. These days, the insolvency practitioners are very much hand in hand with their agent or their valuer. So in terms of deciding whether to accept or reject an offer, it's the insolvency practitioner speaking to their experts. So, you know, in the fashion field, they would tend to have a fashion agent or a fashion valuer appointed, and the fashion valuer would say whether that's a good deal or not. But as I talked about, it's not just necessarily price. They're entitled to sort of, you know, if they're comparing oranges and apples, they're entitled to say, Well, the orange have got the cash in the bank and can move quite quickly. So even though it's a lower deal, lower offer, I'm going to go with the orange rather than the apple that needs to go off and get the application approved by the bank.
Okay, thank you very much for that, Paul. And I think that brings us to the end of this webinar. So thank you, Georgie. Thank you, Paul. I hope that those who have joined us this afternoon have enjoyed this webinar and have found it informative. If there are further questions which you would like to raise, please feel free to contact Paul or Georgie or in extremis me, and we will look forward to answering the questions which you may have. Until then, thank you very much and goodbye.